As far as today's topic is concerned, friends, before I come to the topic, let us once again welcome all the participants, my president, vice president, president-elect for joining. Friends, this particular model law, if you see the history and the legal position, the draft is given by the central government because the domain, the property and the land are the state subjects, and therefore, unless and until the state governments adopt this law, it will not be applicable to that particular state or particular union territory. I will straightforward go to sharing my screen of the presentation. This is the analysis of the draft provisions. Now, in the process of analysis, we need to understand to start with the object of the provision. What is the present state of the laws relating to the controlling of the rent and the tenancies? What is the mechanism within these subjective provisions of the law and the mechanism for dispute redressal? As far as the dispute redressal is concerned, friends, Advocate Vipul, my co-speaker, is going to give detailed submission, a presentation in that regard. I'll straightforward go to the, I will, as I said, I will be looking into object, the present law, the provisions of the current draft rule, dispute redressal will be seen by Vipul, present tenancies, present live-in license, and the leases and the transfer property act are the main topic which I'll be covering in scope of next 25 minutes. Directly coming to the object, friends, as we know, the object is to establish an authority which will be called rent authority with the intention to balance the interests of the landowner and the tenant so that the entire industry, the rent industry, which is not there in our country, in the Western countries and the European countries, entire industry is there for the renting out the premises. There are the rules and regulations. In our nation, so far there is no such segment duly developed, and therefore this law aims to develop that kind of entire industry in the market. The idea is to create an accountable and transparent environment for the landowners to have a trust, confidence, and for the tenants also to be more comfortable, because as of today under the PAGRI system, we know what are the problems we are facing as a tenant. Apart from this, as we know, the present government, central government, has aimed to provide housing for all by 2022, that is 75th year of independence. These particular aspects of rented houses was not looked into by us. The previously our understanding was providing the housing for all means the ownership houses. But even the renting houses is also very important requirement. And by standardizing the available facilities of renting a properly designed and facilitated residential properties, the standard of living of the people will also be improved. Friends, before we go to the analysis of the law, let us have a look at present rent control provision. As the name suggests, the state is controlling authority. It is not the facilitating or regulating authority. That itself is a big obstacle in the development of the industry, because in spite of making almost market value by way of PAGRI, the tenant are at the mercy of the owner of the property. On the other hand, owners are also feeling insecure about availability of their place as and when required. The foremost is the dispute resolution mechanism is completely weak, because the parties have to go to the civil court. There is no special mechanism dedicated to this industry itself, like RERA. As we know, RERA, of course, it is in a nascent stage, but even then, as Ramesh Bhai suggested from time to time, that RERA is really evolving and it is going to deliver very good results. So this is the background of the requirement of the present law. Now, what in nutshell is the model tenancy law? Friends, there is no state control as far as the model law is concerned. It is absolutely based on contract between the parties, means the landowner and the tenant. I'll come to the premises which will be covered under this. But the foremost thing is there has to be compulsorily written agreement. Once the state governments enact the law, model law, as suggested by the central government without diluting its provisions, then it is going to prove boon for the entire new segment of the industry. The contractual obligations between the owner of the property, we call the premises owner or the landowners, and the tenants, is going to govern everything. There will be no government interference. Adjudicating authority will only adjudicate on the basis of the contract only. And these are beautiful aspects of the model, this suggested law. Now, I would like to come to the premises. Which premises will be covered? To start with, first of all, unless we understand at what are the premises will be governed, the clarity will not be there. So all the private land, building and part of the building with garden, parking space close and the garages, these are the premises which will be governed under the law. And once this law is enacted in any state or union territory, nobody will be able to give their premises or the properties on rent without written agreement. We call it written contract. The moment this law is enacted, one of the sections of the new law says that the present rent act will be automatically repealed. There are the saving clauses which will be dealt with by my co-speaker as to what is the status of the current tenancies and legal license and the leases and all these things. But suffice us to say for the time being that premises includes all those buildings. However, it specifically excludes the state government, central government and local government and their corporations ownership properties out of the purview of this law. Another properties which are out of the purview are the public charitable trust properties, religious and charitable purpose properties, then the companies and other organizations or the enterprises which have their own properties in the form of the residential premises, which are exclusively meant for residence of their staff, their employees, their workers, under the terms and conditions of the contract of employment. Those will also be out of the purview of this law. However, all these owners which have been specifically excluded have been given power under the Act to submit themselves to these provisions of this law by making an application to the rent authority. So this is the overall mechanism. Now the starting point is, as we know, as like all government offices, there will be rent authority. If I compare it, currently the deputy registrar, assistant registrar in the office of cooperative society registrar, they are the departmental authorities. Here under this new law, it is called rent authority. They will be equivalent to those authorities. Then comes the rent control and the rent tribunal in the same hierarchy. Rent authority, above them rent court, and above them rent tribunal. This mechanism will be explained in detail by my co-speaker. The most important part, which will be a death nail to the corruption if properly implemented, is the digital platform has been made compulsorily. Within 3 months of establishment of the rent authority, in any platform has to be made ready, and the digital platform has to be in the language, vernacular language or the state language. So it will be widely available in the simple format to all the people of the state. Another important aspect is every rent agreement which will be submitted to the rent authority shall be given an unique number. Say for example, we as an individual get Aadhaar and PAN card. Likewise, every contract of renting shall be given unique identification number, and that number will be the very important number for person who has been given UIN to visit the digital platform to find various aspects, and at all stages, at the preliminary stage in the office of rent authority or at the appellate stage, this number will be the center point for identification. Another aspect, and rather very, very important, is compulsorily all the rent agreement have to be submitted to the rent authority. There is no exception for all those premises which are subject to the provisions of this law. And let us understand that whatever terms and conditions mentioned in the agreement, a contract, are going to be the only evidence before the rent authority, rent control, and rent tribunal. That means the importance of the agreement or the contract of tenancy are not drafted properly. If that is happens under the new provision, then in absence of clarity, the Transfer Property Act and other provisions, and therefore it will be very important for the people to go for drafting to a level which avoids any kind of interpretation beyond the provisions of the Contract Act. Now we have to understand two terms. What is tenancy and what is rent? Now the tenancy is whenever there is an agreement for rent those property, deem extension of the tenancy. Yeah. Now, if say for example, after extension of the tenancy, if the tenant does not vacate, then he will have to continue to pay the maintain the premises also, and he will have to pay the rent also. However, if he defaults beyond the period of 6 months of the deemed tenancy, then the consequences of that will be extremely heavy for the tenant, and that is guaranteed to the owner of the property that his property is safe and will be vacated, and the court, the authority, the court and the tribunal will interfere. Now, what are those consequences? For the first 2 months, the tenant will have to pay double the rent agreed upon between the owner and the tenant in the contract of tenancy rent. And after 2 months, the tenant has to pay 4 times the rent. Say, for example, the rent for 2-bedroom kitchen hall property in the western suburb near Andheri is 45 or 50,000 rupees. He has to pay 1 lakh rupees per month for first 2 months, and double that means 2 lakhs rupees. So it will be very expensive for the tenant. So this is also a very important aspect, and that guarantees to the property owner also, as far as the tenant is ready to observe the terms and conditions of the contract of rent or tenancy, he should not be worried about. Another most aspect where the current present controlling rent act, most of the disputes are about change of name when the tenant expires. We call it successor. Under the amended, the suggested Model Tenancy Act, the successor of the owner as well as the successors of the tenant, both are within the purview of the provisions. When a property owner expires, his legal heir, his successor, and when the tenant expires, his legal heir and his successor will be bound by the agreement, contract. Say, for example, if the contract is for 2 years and in the midway the tenant expires, then his legal heir will step into his shoes and they will have to pay the rent and maintain the properties and etc. Another aspect in which under the present law there is a huge litigation like the previous one is subletting of the property. Under the present law, the subletting of the property is not allowed, point blank. Under the model law, it is open to the parties to provide within the contract itself that tenant will be able to sublet or not sublet. He will be able to sublet without giving notice to the owner or what, whether he'll be able to sublet with whatever rent. If nothing is mentioned in the agreement, then also it is possible for the tenant to sublet by written consent of the owner. The only condition is that in that case, he cannot take the rent higher than the one which he is paying to the landowner, property owner. Going further, like the tenancy, another most important part is the rent. The agreement between the landowner and the tenant has to mention very clearly as to what will the rent. Not only that, when the revision of the rent will take place, the methodology and calculation of the increase of the rent can also be part of the agreement. However, if nothing is mentioned about revision of the rent, then in that case, it is open to tenant. It is rather open to the landowner to send a notice to the tenant, 3 months notice, that I would like to increase my rent by such and such amount. If you are not agreeable, please vacate. If the tenant fails to vacate or fails to communicate, then in that case, the tenancies shall be deemed to have been continued on the revised term as per the notice given by the owner of the property. To take care of these aspects while drafting also and using the property. If the tenant wants to vacate the premises before the completion of the terms of the tenancy, or even though there is no completion of terms of tenancy, or even after completion of tenancy, if he has continued within the period of 6 months or extended period, if he fails to give the notice of the termination, then again he is inviting the problem of deemed extension of the tenancy. Then the rent authority will be the only adjudicating authority at the lowest level to whom the tenant or the landowner will approach for ultimate adjudication as to whether the premises are to be vacated, tenancy will continue, what rent will be paid, or whether there will be revision of rent. As far as the revision of the rent is concerned, an application can be made by the owner also, as well as by the tenant also. Tenant will ask for revision at lower level and the landlord will ask for the revision at the higher level. Both these persons can go to the court. There can be various factors for revision. I'll give 1 or 2 examples. Say for example, after giving the property on rent, the landlord makes certain additions, improvements and alterations which are not within Schedule 2 in his part. In that case, he will have a right to apply to the rent authority for upward revision of the rent, and the rent authority will have the jurisdiction to adjudicate this and order accordingly. The next very important aspect is security deposit. It has been specifically mentioned that for the residential premises, the security deposit will not be more than 2 months rent. And in case of commercial property, within this provision, you have to draft a document of rent and tenancy. This security deposit cannot be more than what has been prescribed. Say for example, 2 months for the residence and minimum 1 month for the commercial. Now coming to the last leg of our discussion about the obligations of the landowner and the tenant. This is also extremely important because, as I said, I'll repeat once again that the contract is very important. The obligations of the landlord tenants are also there to be in the agreement of the contract only. Like the terms of tenancy, terms of rent, renewal of tenancy, vacating the premises, who will maintain, all these aspects are covered under the Contract Act. Likewise, the obligation of the landowner and the tenants are also to be completely covered in the contract itself. The first of all, friend, okay, before coming to this, one important aspect which remains is, see, Schedule 2, the Model Act specifies as to what will be repaid and conditions by the owner and what will be repaired and conditioned by the tenant. The schedule is very clear. Even we can understand that by and large it is rational and proper. Say for example, the structure repair, which we now understand, whitewashing the premises, painting of the premises, changing the plumbing system and external electrical wiring and internal electrical wiring. These are the domain of the landowner. Whereas the regular maintenance kind of thing, switches, bulbs, tubes, draining system, water closet, all these are part of the repairing, which is the responsibility of the tenant. If the tenant repairs something more than what is he is required to do under the contract or under the schedule, then he will have a right to ask for adjustment of the payment against the rent. Likewise, if the landlord has repaid something which is not done by the, which is within the purview of the tenant, and the landlord repairs it, then in that case, he will have a right for upper revision or the additional payment or reimbursement of expenses for which both these persons, the owner and the tenant, have to approach the rent authority. Coming back to the slide, once the agreement is signed by both the parties, duly witnessed, under the present position, most of the time the rent agreement is not entered into or not given to the tenant. Here it is compulsory that one original signed copy, signed by both the persons, tenant and the owner, has to be given to the tenant. Second, whenever the tenant makes a payment of rent, either to the landowner or to his manager, which is termed as a property manager under the provisions of the Act, then compulsorily a written receipt has to be given for such payment. And in case the landowner or the property manager of the landowner does not give the receipt, or he does not accept the rent, then unlike the present dispensation when we have to go for litigation immediately, under the model law, for 2 months, the tenant can send the rent by money order or by any other electronic mode as may be subsequently prescribed by the rules under the government, under the rules that may come. However, after 2 months also, the rent is not accepted, then the tenant has to deposit such rent with the rent authority, and the landlord will be at liberty to withdraw the amount from the rent authority. Now, when he withdraws the amount, he may withdraw a particular part of it as per the agreement. However, a withdrawal in itself cannot be taken a ground by the tenant that the landlord has accepted his terms and conditions. So this is also a safety of the landowner, that even he accepts, he does not accept the terms and conditions of the, as may have been suggested by the tenant. In the agreement itself, the common utility among, say for example, entire building is tenanted, entire building. Then in that case, it is open to the parties to mention in the agreement of the contract itself as to what are the utilities for which the tenant has to separately pay, what are the common utilities and the common facilities for which the tenant has to pay separately. So this has to be again as per the agreement. Then, as I suggest, just now brush to the schedule 2, to the model provision. Part A and Part B mean for owner and the tenant respectively. If they respectively fail to do or perform their part, then the other party will be able to do it and recover the expenses from the other side who was responsible. And for adjudication of any difference or dispute in this regard, they can approach the rent authority. Coming to the repossession of the premises by landowner, because that is the main contention litigation part as of today in the courts, is when the landlord wants to repossess the property on expiry of the term of the contract. Under the model law, it will be very easy. It will be as per the contract between the parties. And the adjudicating authority will also immediately pass an order, and there will be no scope for 20-25 years in the civil code. As far as the tenancy continues under the terms of the contract between the two parties, eviction of tenant will not be possible under any circumstances, unless the terms of eviction midway have been very clearly specified in the contract. And therefore, there is a surety to the tenant that he will not be on the road if he is ready to perform his part of the contract as per the terms and conditions. However, if the owner is of the opinion that the tenant is misusing the premises, then at any point of time, irrespective of the terms of the contract, he can approach the authority for an order for eviction of the tenant. Now, it is very important for us to understand what is the misuse. See, the misuse is defined very clearly under the provisions. If any activities which are, I'll just go through that provision. What is, yeah, misusing means encroachment of additional space by the tenant, use of premises which causes public nuisance or causes damage to the property or is detrimental to the interest of the landowner or for immoral and illegal purposes. For these purposes, during the continuance of the terms of the contract also, the authorities will be able to pass the order of eviction. In this regard, at present, provisions and the adjudication is very long drawn legal process, and therefore this is also a very important provision. Another important part under the present dispensation, it is not easy for the landowner or the owner of the property to get the property vacated if he wants to repair it, if he wants to make some additional construction. Say, for example, if certain construction is necessary for the landowner to safeguard his property, then under the present provision, it is not easy for the landowner to get the property vacated. Under the present, the model law, it will be possible for the landowner to get the possession of the property back from the tenant by approaching the rent authority, who will see that it is a genuine requirement of the landowner. He has got the plan ready for repair. He has got the contract and everything ready, and then he will pass the. However, during this period of vacating the property, if the tenants fails, even after the order or notice or agreement, then he'll have to face the consequences. And the consequences, as I said, are very harsh. That is, for first 2 months, double the rent, and subsequent 4 months, 4 times the rent. Say, for example, in an entire rented building, there is a plot of land which is vacant, on which there is no construction. And that is also part of the renting agreement. If the landowner wants to develop that particular part after getting FSI or under the new revised DC rules or whatever reason, if he is able to construct, then under the present law, it is very difficult for him to get the construction, get the property vacated. However, there is a specific provision that the rent authority has been given power to pass an order of severance of the land for permitting additional construction. But for that, the precondition is that the plans have to be ready. The landowner has to be really ready for starting the construction. Otherwise, he will not be able to get the order. So, severance of the land for permitted additional construction is a very important thing. This is also an assurance to the landowner that he will not face any problem for security and repossession of his property. Another totally new factor is possession on determination of interest of the landowner. Say, for example, for some reason, for any reason rather, if interest of the landowner is determined in any property, then that itself will be a reason for him to approach the authority to get an order for termination of the tenancy and for eviction of the tenant. Tenant's notice to give possession. This is a part of that process only. If under the contract, if the tenant is eligible to get the possession of the property for the purpose of, if he is ready to perform his part of the contract, then the adjudicating authority will definitely pass an order in that regard. Now, having understood almost all the aspects in nutshell about the Modern Tenancy Act, friends, the questions are: what happens to the present tenancies? What happens to the present leases? And what happens to the present live-in license agreement? In this regard, there is complete clarity as far as the new law is concerned, because the new law is totally applicable all the contract only after enactment of the law. Means there is no retrospective application, and therefore the present tenancies, present leases under the Transfer of Property Act, as well as present live-in license will not be affected by the new law. There is no provision also for these things to be covered under the provisions of the modern new law. Unless, say for example, presently there is a tenancy, if they want to cover, they have to get out of it and enter into new contract. As far as live-in license, friend, is concerned, in the last lecture where the same my co-speaker was there, Vipul Shah, we had analyzed in detail the difference between live-in license and the tenancy. Live-in license is a kind of license given. No interest in the property is given to the licensee. It is for the limited purpose. That purpose will be for the residence. For purpose will be for doing some work. The purpose will be for redevelopment of property. By and large, as we understand, live-in license is that we give the property for residence, and for the purpose of that license, he is allowed to enter our flat, but he doesn't have any interest in the property. These documents will not have any effect. It will not be affected by the Modern Tenancy Act. However, let me draw your attention that under the Maharashtra Rent Control Act, Section 24 is there, which gives a protection to the flat owner and the live-in licensee also to approach that authority for various remedies as per the live-in license agreement. If the new law is adopted by the state government and that kind of provisions equal to Section 24 are not enacted, then all these cases have to go to the civil court with long drawn litigation process. Friends, with this I have tried to analyze the provisions in the context of the present law, as well as the aim and object of the new law. Thank you, friends.